we have seen that how the case laws are important, right? Whether you are a law student or whether you are a legal professional, or if you are preparing for any competitive exams, the case laws are the most important part of the law school journey. And although I kind of faced difficulty while compiling case laws because there are so many important case laws that came into being in 2024, however, I have kind of compiled 10 most important ones, mostly the constitutional bench judgments, and we can just discuss the analysis of it, what exactly are the facts of the case and how the court observed it. And we can also make it a very interactive session. You can also add your own inputs or can ask questions, but I would request you all to keep the questions till the end so that it does not interrupt the session. Now I will be sharing the screen. So I have made a list of the cases. As you can see, that the first one is the Association for Democratic Reforms versus Union of India. Then we will be discussing the state of Uttar Pradesh versus Vaish. Then the state of Punjab versus Davinder Singh. Then the Property Owners Association versus state of Maharashtra. Then the AMU verdict, the popular one. And then we will be discussing the Mineral Rights or Mineral Area Development Authority versus CEL. And then the Association for Democratic Reforms versus ECI, also known as the EVM VVPAT judgment. Then we will be discussing the Gaurav Kumar versus Union of India. And then we will move on to the Sukanya Shantha versus Union of India. And last would be our Bulldozer Action judgment. So first is the Association of Democratic Reforms versus Union of India electoral bond judgment. I think most of us are already aware of this judgment since it has become very controversial as well as popular and took up to the medias all over. Like in the month of February, it became very much controversial. People started writing articles on it. So because of which I have seen that law students have become aware of this case law. But however, it is very important for us to know that what exactly was the background of the case, what led to the electoral bond scheme, why electoral bond scheme was struck down by the Supreme Court, and why it was held to be unconstitutional. Before I start discussing the case law, I would like to ask you all what you guys think that electoral bond is, or what is your idea of electoral bond. You can just unmute yourself and give me the answer. Would anyone like to answer what exactly is an electoral bond? What we know about it? Yes, Rajan.
Ma'am, electoral bonds basically is an instrument like before 2018, all the payments which were made to the political parties were either in cash or from different sources. But after 2000, government to regularize it and to have the evidence that who has paid the money, they find out a way, that is instrument, how that by this bond anyone can pay to the different political parties, but the who is gonna pay it, no one is going the name, but it will be with the banks or the setup who is doing it. So
yes, so electoral bond is nothing but a promissory note. What do we know about promissory note? See, promissory note is one of the negotiable instruments. If you already guys have read the NI Act, you would know that promissory note, bill of exchange, these are negotiable instruments. These are financial instruments. So promissory note is nothing but a written agreement between the lender and the person who is lending the money. So payer and the payee, it kind of creates a bond or obligation that he would pay the money back on time. So that is a promissory note. But what makes electoral bond different from promissory note? That we have to know. Now, in the promissory note, what we see is that the identities of the payers and the payee, these things are known to us. We know that whom we are paying, who is the payer, who is the paying the money. But what happens in the electoral bond is that the entire identity of the person making the donation, it is anonymous. It is kept anonymous, because of which it becomes shady. Because we have seen that the political parties, they get huge amount of donation in every election. I mean, if you guys have seen that how the rallies take place and how the campaigns take place, they spend exorbitant amount of money. How is it being possible? Because they are getting donations, and the denominations that can be of electoral bond, that can go up to 1 crore rupees. So many articles have already stated that how 96% of the donation to the political parties was around 1 crore. So it is kind of creating a quid pro quo system. Now we would take a look at the background of the electoral bond scheme, how the scheme came into being. So on 1st February 2017, the Finance Bill 2017 introduced an electoral bond scheme, EBS, which allowed the domestic and the foreign corporations to make donations to the political parties while improving the transparency in electoral funding. So the primary motive of the electoral bond scheme was to maintain the transparency, because they believe that if we are not making the donation directly to the as a person, then it would maintain the transparency and nobody would be able to know who is making the donation. But ultimately or gradually it turned into something else. To facilitate the donation, the donor can purchase electoral bonds. That's what was thought from this SBI, State Bank of India, instead of using cash, because the bond can be encashed at the SBI only. Now, under this scheme, the donations are made in the nature of a promissory note where the identity of the donor is kept confidential. Now, the case was actually filed, or the petition was actually filed by the CPIM, the Communist Party of India Marxist, before the Supreme Court, who filed a writ petition under Article 32. We know Article 32 states the constitutional remedies under the Indian Constitution. So, after the petition was filed on the grounds that the concerned amendments violate the right to information. Right to information, which is enumerated in Article 19(1)(a). So the right to free and fair election, that it does not fall under any of the reasonable restrictions under Article 19(2). So we as the voters, we have the right to know that whom we are electing, whether the parties who we are electing, they are getting any donations from the outside or not, whether there is a flow of money which we are not aware of or not. That is our right, that we are supposed to know, that we are entitled to know. Now, what happens is that when the business tycoons, the business industrialists, they are making donations just to get something in exchange or expecting something to get in exchange, we are always kept in the dark. We don't know what is happening behind all this. So we are just voting the candidates, not knowing what is happening. So this is violative of the Article 19(1)(a) completely. Now, the questions of law, which were before the court of law, whether it is being violative of Article 14 or Section 182 of the Companies Act, or whether it is being violative of Article 19 of the Constitution. Now, non-disclosure of the information on voluntary contribution is also infringing the Section 29C of the Representation of the People Act. So it is altogether disregarding the foundational principle of the election, because democracy stands on a free and fair election where nothing should be kept in the dark. Nothing should be kept hidden from the voters. That's why you would see that before election, the financial records, the criminal records of the political parties and the candidates, those are actually published. So this is also, we are entitled to all this information. Now, electoral bond was being violative of that. Now, the challenge in the Supreme Court, it was filed before the Supreme Court of Law. And on 15th February, the court unanimously struck down the union's 2018 electoral bond scheme. The bench held that the scheme violated the voters' right to information enshrined in Article 19(1)(a) of the Constitution. The court also directed that the sale of electoral bonds be stopped with the immediate effect. SBI also was directed to submit the details. And if you had followed the news at that time, you must have seen that how SBI was making the entire process very delayed, and they were reluctant to publish the entire data, which makes it evident that there is always some influence going on behind all these things. So ultimately, the SBI did publish the list, and we got to know that how the business industrialists and the business tycoons, they made a huge amount of donation to the political parties. Now, the Supreme Court, in deciding various pleas and striking down the scheme as unconstitutional, answered the two crucial questions, which were the questions of law, as I already have stated, the Section 29C of the RPA, Representation of People Act, and the 182(3) of the Companies Act, as well as the Section Article 19 of the Constitution, that is the right to information. Now, these were being violative since Supreme Court answered these two questions and deliberated upon these two crucial points of law. Now, the main concerns that were raised by the Supreme Court were the quid pro quo concerns. So, what is quid pro quo? Quid pro quo is you are giving something to someone, in exchange you are also expecting something. So, this is quid pro quo. An election cannot be based on that fact that I am voting you, in exchange of that I am also expecting some favors from you. That cannot happen. So, you are making the donation, in exchange of that you are also expecting the political parties to favor you on some principles, on some policies, maybe things like that. So it is completely the violation of Article 14, Article 15, as well as Article 19(1)(a), because we citizens, we are not aware of these things, what is going on. And it is unlimited corporate donations and fair elections are actually prejudiced by this. And it is also failing to meet the proportionality test of the elections. So because of which altogether this entire electoral bond scheme was struck down in February. Now, this was our first case law. So after the electoral bond scheme was struck down, several guidelines were also published by Supreme Court. Directions were given to SBI to stop the issuance of the electoral bonds, as well as those electoral bonds which had already been given beforehand. Those were also supposed to be returned to the purchaser within the 15 days. So that's how Supreme Court dealt with the electoral bond scheme, and the unconstitutionality of the electoral bond scheme was actually highlighted through this case law. So it is actually one of the important case law of 2024, especially in regard to the democracy, elections, and the impartiality of the elections. Next, we will see the state of Uttar Pradesh versus Lalta Prasad Vaish, that is the industrial alcohol case. Now, what exactly is an industrial alcohol? What do you understand by an industrial alcohol? You can just unmute yourself and answer. Farhan Sheikh. Anyone would like to answer what exactly is an industrial
alcohol, which is mostly
alcohol?
used in...
What do you mean by that? Sorry?
Alcohol which is mostly used in industries and are like mostly not suitable for human consumption.
Right. So there are two different types of alcohol: potable alcohol and non-potable alcohol. Potable alcohols are those alcohol which are for human consumption. Non-potable alcohols are not for human consumption. Now, in every case law, you would see there is always a precedent. Precedent as in the case law is always following from the previous case law, and the judgment is either being overruled or by being upheld. Now, this case law also has a precedent, which is, we will come down to that later, but let's take a look at the brief background of the case. Now, the legal dispute originated from a complex series of challenges to state legislative powers regarding the regulation and taxation of industrial alcohol in India. The controversy emerged when several states, including UP, enacted legislation to regulate and tax industrial alcohol, citing legitimate concerns about public health and the prevention of its diversion into potable alcohol. So we know that how the powers between the state legislative assemblies, the state governments, and the central governments are different. We know that we have three lists, that is the state list, union list, and concurrent list. Union list deals with the matters upon which the union government only has an upper hand or the authority to regulate or to control. Whereas on the other hand, in the state list, we see that there are subject matters upon which only the state governments can control or show their authority. On the other hand, we see the concurrent list, which combines of all the matters upon which both the state governments as well as the central government, they can show their authority. Now, what we have seen is that the state government, whether they do have the authority to control the manufacturing, production of the industrial alcohol or not, this was questioned in this case. Now, pivotal movement in this legal discourse came with the 1997 Judge Bench decision in Synthetics and Chemical Limited. So in this case only, it was clearly stated that if you have seen the entry 8 of list 2, 7th schedule deals with the state list, where it has already been clearly stated that the state governments do have an authority to control the manufacturing and production of the intoxicating liquor. Now, what is intoxicating liquor? That needs a constitutional interpretation. This was subject to the case law. This was subject to the higher bench, where it was stated that the intoxicating liquor does include both the alcohols, potable alcohols, as well as the non-potable alcohols. Now, the aftermath of the synthetics ruling saw divergent interpretation by various high courts across the country, where some courts upheld the state regulation as necessary measures for preventing misuse, as well as the judicial divergence created a complex wave of inconsistent enforcement patterns across the states. Now, because of which this synthetic judgment needed an overlook, needed to be gone through once again, because it clearly prohibited the state governments from regulating or controlling the production and manufacturing of the non-potable alcohols, that is the industrial alcohols, and the entire power and authority of the state legislative assemblies as well as the state governments were limited to the only potable alcohols. Now what we see is that The court begins by analyzing the distribution of legislative powers between the union and states under Article 246 of the Constitution. It emphasizes that while Parliament has predominant power, the supremacy only operates in cases of irreconcilable conflict between union and state list interests. The court stresses the need for a holistic interpretation of the notwithstanding and subject to clauses in Article 246, aiming to maintain the federal balance by defining the scope of Parliament's predominance. So whenever the central government, they are encroaching or they are actually intervening into the work of the state governments, that is actually an encroachment of the power or a misuse of power, because you are not supposed to go into the working of the state governments. Whatever works you have been assigned, control that, regulate that. But when you are actually doing the job of the state governments, that is an encroachment of the power. The separation of the power is no longer there, and the federal balance or the equilibrium is also disrupted. Now, the court examines the language and structure of the legislative list in the 7th schedule. It notes that interests define broad fields of legislation, not specific powers, and that the list distinguish between general and the taxation entries. So when we will be reading the minerals rights case, we will also see that how it is similar to this case. Now the court assesses the relevance of Tika Ramji. This is another case which was cited as a precedent in this case, and it is irrelevant because its interpretation of industry does not affect the court's interpretation of entry 8. Entry 8 or list 2 of the 7th schedule is all about the state list and the production and manufacturing of the intoxicating liquor. The court directly addresses the synthetic judgment, finding its reasoning flawed. It criticizes the synthetics for not independently analyzing the meaning of intoxicating liquor and for incorrectly assuming a lack of awareness regarding industrial alcohol's potential in FN Balsara. FN Balsara is another constitutional bench judgment which also dealt with the same matter, the main federal balance between state government as well as the central government. The court overrules several aspects of synthetics, including its narrow interpretation of intoxicating liquor and its assertion that IDRA grants the union exclusive competence over both potable and non-potable alcohol. Now, this is a timeline, or not exactly a timeline, rather the issues and the majority and dissenting opinion. Now, I have taken it from a very popular website. However, if you go through this PPT will be shared with you all, but if you go through this, you would be able to understand that what exactly was the majority opinion and what was the dissenting opinion. So it will give a very clear understanding of the case law and an analysis of the case law. Now, next, we will move on to our another case law, that is the state of Punjab versus Davinder Singh, subclassification of SC and ST. Now, scheduled caste, scheduled tribes, or the other backward classes, OBC. These are the homogeneous group of people. Under the Article 341, only the President has the authority to subclassify it. Now, it dates back to the case of Indra Shahani versus Union of India. It was another 9-judge bench case, where it was held that the OBC can be subclassified as per the needs. Because what we see is that in the backward classes, there are some classes which they are more backward than the other people. So this is what happened in this Davinder Singh case as well. So there was one issue or guideline issued by the Punjab government where 25% reservation was kept for the Mahijibhi Sheikhs and Balmiki Sheikhs under the SC community. It was a subclassification of the SC-ST community. So the Supreme Court of India was tasked with reviewing the constitutionality, whether subclassification can actually be done or not. Specifically, the court revisited the principle of the case of E.V. Chinnaya versus State of Andhra Pradesh, which had ruled against the subclassification. So, in this case, Davinder Singh case, Supreme Court overruled this E.V. Chinnaya judgment. In E.V. Chinnaya judgment, the entire subclassification was held to be unconstitutional. But in this case, it was overruled and it was stated that subclassification is okay and subclassification is allowed to do when it is needed. Now, under Article 341(1) of the Constitution formed one class of homogeneous group and the same could not be further subdivided. So, the matter was referred to a 7-judge bench to resolve whether states could create separate quotas for more backward subgroups or not. Now, brief background, we see that E.V. Chinnaya judgment, the Supreme Court had decided that the scheduled caste form one homogeneous group and their subdivision would be the violation of Article 14. Article 14, as well as it would violate the reasonable classification and the intelligible differentia of the classification of the SC and ST. That is why E.V. Chinnaya kind of struck it down as being unconstitutional. Now, in the next, when the case moved on to the Davinder Pal Singh, when the case came into being, when it was moved to the larger bench, it was stated that the issues, the questions of law, whether the state had the legislative competency to enact provisions contained under section 4.5 of the Punjab scheduled caste to subclassify or not, whether it can do it or not, whether does it have the power or not. Now, it was held that yes, it can be further classified without violating the constitution's equality principles or article 341. There is no conflict with article 15 and 16 in creating subcategories within a caste. Also, states must provide concrete evidence of underrepresentation when forming these subgroups, not based on arbitrary or political reason. So when you are subclassifying the caste, you have to make sure that you are doing it for the economic well-being or economic benefit of that class only. When you are doing it for the political reason, what we have seen is that how the elections are taking place simply on the basis of vote banks and the caste groups, all these things are taken into account because you want in order to get more votes. We have seen that how the communities are being targeted for these things. So when you are doing it for political reasons, that is arbitrary. That is a misuse of power. But when you are doing it for the holistic development of the same classes, that is not unreasonable. Additionally, such decisions are subject to judicial review as well. Now, the state has to give preferential treatment to the more backward communities. Only a few people of SC and ST are enjoying reservation. The mistake in E.V. Chinnai's judgment was thinking that Article 351 is the basis of reservation, but it only identifies caste for reservation. The grounds for subclassification is that a group from the larger group faces more discrimination. We know that when suppose there are two groups of people, one group of people need more attention than the other group of people. There are two children, one child is sick, another child is not. That sick child needs more attention, right? That's how these things work. When you know that the other group of people need more attention, maybe they are actually facing the persecution, they are facing the torture, they are facing the discrimination more than the other group is facing. So you are automatically allowed to subclassify it into two categories so that the other group can get more benefits since they are not getting the same treatment as the another group. Now, in dissenting opinion is always there. Justice Trivedi said that states cannot alter the presidential list of scheduled castes because it is completely a president's discretion. We are taking the law in our hand. The state legislative assemblies, they cannot take the law in their hand and they cannot do that what the president is supposed to do. So this is the Davinder Pal Singh case. Now we will see another important case, that is the Property Owners Association versus State of Maharashtra. Now, what do you mean by a private property and the public property? Like, what do you understand about that? If you have any understanding, just can unmute yourself and say that. What is public property and what is private property? Yes, Rajan?
Public property is something which is basically of the government who has every public has the right, like roads and public parks. Private properties are the properties which is owned by private persons like individuals or a company or a firm, something like that.
Okay, so do you guys think that the state governments or the government, they do have the authority to take the private property from the people for their own benefit or for any work of the government? Do you think is it possible?
Yes.
Yes, for national good, they can sponsor the private property.
So this case is all about that. Now, it dates back to the Mumbai's dense population. There is another act of the Maharashtra Housing and Area Development Act. We will be deliberating upon that act. Now, what exactly is the background of the case? Let's take a look at it. Now, Mumbai's dense population and aging infrastructure, particularly its numerous dilapidated pre-1940 buildings, presented a significant challenge. Building collapses resulted in loss of life and property, prompting the enactment of various laws to address the issue. The Bombay Housing Board Act and the Bombay Building Repairs and Reconstruction Board Act were initial attempt to improve the housing and repair dangerous buildings. So the Maharashtra Housing and Area Development Act consolidated and amended the existing housing laws. Chapter 8 of the MHADA Act addressed the repair and reconstruction of dilapidated buildings in Mumbai, categorizing them into A, B, C based on the construction dates. Now, a significant amendment introduced a mechanism for the acquisition of category A buildings by the state and their transfer to cooperative societies of occupiers. So, what we know is that in some cases, the private properties can be taken up by the government. But this case is all about that how would you know that what exactly can be a private property? What are the criteria that the private properties need to be fulfilled in order to be considered as a material resource of the government? Now, the property owners challenged the constitutionality of the Chapter 8A of this MHADA Act. It argued that it violated the Article 14 and 19. The High Court dismissed the challenge, holding that the provisions were saved by Article 31C. Article 31C is a saving clause. And if you have read the Keshavananda Bharati case, we all know this is a popular case of the non-scheduled case. This 31C was actually upheld in the Keshavananda Bharati due to their nexus with Article 39B. 39B is also about this private property. Now, the Supreme Court then grappled with the question of Article 31C's continued validity post-Minerva Mills case, the interpretation of Article 39B leading to the eventual referral to the 9-judge bench. So, it was referred to a 9-judge bench, a higher judge bench, and because there are land laws in state of West Bengal, UP, all the states, they do have their personal land laws. So, it always happens that there is a conflict, there is a confrontation in between the laws, because of which it needed a very thorough analysis. And it moved to the higher judge bench. The Supreme Court of India addresses the constitutionality of the Chapter 8A of this MHADA Act. The appellants, they are the Property Owners Association, and others challenge the Act provision, arguing they violated the Article 14 and Article 19 of the Constitution. The respondents and this of the state Maharashtra and others countered the Act was protected by Article 31C, as it gave effect to the principle of 39B. So the case's journey through multiple reference orders to larger benches ultimately led to a 9-judge bench or the constitutional bench judgment. Now the central issue revolves around the interpretation of material resources of the community. So what exactly is the material resources of the community? On which resources the community, means the government, they do have the authority. Whether they can acquire all the properties, all the private properties, can they do that? That will be an arbitrary action, right? Like whatever private property we have got, if the government comes and takes it away, then it will be kind of an arbitrary decision. So there has to be a rational nexus. Otherwise, it will completely violate the Article 14. Now we will see the findings of the court. Before that, questions of law come into being. So thus, Article 31C, as upheld in Keshavananda Bharati, survive after the invalidation of the 42nd Amendment in Minerva Mills. Can privately owned resources be included within material resources of the community under Article 39B or not? Should the expansive interpretation of Article 39B in Ranganatha Reddy and Sanjeev Co. be reconsidered? The SC found no constitutional defects in the original text of Article 31C. As affirmed in the case of Keshavananda Bharati and Vaman Rao is another case, it further ruled that protection granted to laws for implementing any DPSP. So 39B is a DPSP, okay. So, which were introduced during the emergency by way of the 42nd Amendment remain unconstitutional and void. As established in the case of Minerva Mills, Article 31C remains strictly limited to the laws giving effect to 39B and 39C. Now, the Apex Court rejected the appellant's contentions as well that the invalidation of the 42nd Amendment did not restore the original text. The court explained that the amendment represented a single indivisible act of both repeal and substitution. The SC observed that in the case of Minerva Mills, Section 4 of the 42nd Amendment was held to be in violation of the principles that form the basic structure of the Constitution. We know that how many laws or how many amendments come into being, irrespective of that, the basic structure of the Constitution has to be kept intact. It cannot be tampered with, it cannot be altered, it cannot be amended. Now, what we see is that the court analyzed the interpretation of Article 39B and the court held that not all private properties can be considered as part of the material resources of the community. There has to be a criteria which the private properties need to fulfill in order to be considered as the material resources of the community. Otherwise, it becomes arbitrary and unreasonable completely. So there was another dissenting opinion by Justice Dhulia, who concurred with the majority regarding the survival of 31C. However, he challenged the majority's interpretation regarding the Article 39B. He supported the broad interpretation that was established in the Ranganatha Reddy and Sanjeev Co., where the all privately owned institutions inherently constitute the material resources. So we have come down to two case laws in the precedents that we find, Ranganatha Reddy and the Sanjeev Co., where a broader interpretation was given as per the 39B, where it was held that all the private properties are the material resources of the community. But this case law, we can say it gave a very narrower interpretation, saying that not all private properties can be considered to be a material resources of the community. Next, we would see the AMU verdict, the popular Aligarh Muslim University verdict of the minority status of the AMU. So before I start with the analysis, there is this timeline that I need all of you to see. Now, 1875, AMU was established by Sir Syed Ahmed Khan, the Muhammad Anglo-Oriental College, which was later turned into AMU. Now, in 1920, the college was made into AMU by the Indian Legislative Council, passing the Aligarh Muslim University Act. So you have to know that AMU is governed by a statute or by an act. Now, the main question of law in this case is Article 30. Article 30 of the Constitution grants the minority status of the education institution so that they can administer and manage their own education institutions. Now, the question which arose in this Aziz Basa case, whether the AMU can be given a minority status or not, whether the AMU falls within that purview or not. In 1981, the Act to assert the university's minority status was amended by the Parliament, and in 2005, the Allahabad High Court struck down the 1981 amendment and held that AMU was not a minority institution. Aziz Basa case completely discarded the view that AMU is not a minority institution. Since it has been governed by an act, separate act, so it is not a minority institution. In 2024, the landmark judgment came into being which overruled this Aziz Basa case. Now we will see the background of the case a bit. On 8 November, a 7-judge bench ruled this. So while doing so, the majority struck down the Aziz Basa case. Now, in the Aziz Basa case, what we see is that the main question of law was that AMU should be given the minority institution status. Why? Because AMU should have the authority to conduct or to administer or to manage their own institutional affairs on their own. Because what happens is that when an education institution is formed by a minority group of people, let's say Muslims form this AMU, so they are belonging to that community, minority. Now they are entitled to that minority protection, minority status. So in Aziz Basa case, they completely discarded that view. They stated that no, AMU is governed by AMU Act. They have their own act. They have their own statute. So it is not supposed to be given the minority status as per the Article 30. But this case law, this AMU verdict, this Naresh Agarwal case, is a broader interpretation of the AMU verdict. It stated the AMU, the Aligarh Muslim University, they do deserve the minority status. Just because it has been formed by the statute, that doesn't mean that the minority status will be taken away from them. So these are the questions of law which were put forth. What are the criteria that need to be established for a minority institution? Whether the envisaged institution which is established by a minority with participation from members of the other communities or not. Whether the decision, this court in Professor Yashpal versus State of Chhattisgarh and the amendment of the National Commission for Minority Education Institution have a bearing on the question or not. So these were the questions of law, and this is the timeline. Now, another case law, that is another popular case law like the Property Owners Association. While discussing it, I said that it will be a similar case law. So this is the Mineral Area Development Authority versus SAIL. What exactly is a mineral right? What do you mean? What do you understand by the mineral right? You can just unmute yourself and state. What do you mean by mineral rights?
The right over the natural resources under the soil.
Right. So, what was the question of law in this case law? That on the natural resources of our country, whether the state governments, they do have the authority to impose tax or not. And what is the difference between a royalty and a tax? Whether a royalty can be considered to be a tax or a tax is a separate, distinct issue. Now, this 7-judge bench in the case of India Cement Limited versus State of Tamil Nadu laid down that royalty was a tax. What is royalty? Do you know what is royalty? I would like to ask you all before I move on to the discussion. What exactly is a royalty?
The royalty
It is the tax on subsoil assets. Assets under the soil.
Right. So it is like a payment made to the person. It can be for the intellectual property rights as well, IPR. It can be for natural resources as well. So there is a difference between royalty and the tax. Royalty is when you are using it, the person, you are giving a certain amount of money to the owner of whose natural resources it is, or of whose intellectual property it is. If you have the copyright of someone's, you are supposed to pay royalty. If you have the trademark, same goes for the patent. So this is what exactly a royalty. Now, what is the difference between royalty and the tax? This is the question of law that was put forth. First, in the India Cement Limited versus State of Tamil Nadu. In this case, the state governments, they were not given a right. They were not given a right to impose a tax on the mineral rights, like the way we saw in the Property Owners Association as well, right? And even in the case of industrial alcohol, we saw that how the state governments, their authority was restricted in the previous case. In the industrial alcohol case, what we saw, that in the synthetic judgment, the entire competency of the legislative governments, it was restricted, and it was stated that they do not have the authority. Now, same goes for the mineral rights. It deals with the important issue of the distribution of the legislative powers between the union and the states as regards the taxation of the mineral rights. It also decided on the nature of royalty insofar as it is applicable to the minerals. So initially about 11 questions were recorded by a 3-judge bench as having to be determined. During the hearing before the 9-judge bench, there was consensus between the counsels for the petitioners and the respondents as to the questions that were to be determined by the 9-judge bench. So the Supreme Court did not discuss these aspects in the decision. The questions to be determined reduced from 11 to merely 5. This was the bench. You can see the 9 judges bench. Now, on July 25, the 9-judge bench headed by Chief Justice D.Y. Chandrachud, they held that royalty is not a tax. Royalty and tax, these two things are different. So, it arises out of a contractual conditions of the mining lease, and thus the power of the state legislature to impose tax on the mineral rights and mineral bearing land is not limited by the royalty imposed by the laws of the parliament. So parliaments, they do have the right to enact laws, but they cannot restrict the power of the state legislature or the state governments to control the rights or to impose taxes. Now, next we see that what were the findings, further findings. The substantive issue before the SC was ascertaining the ambit of constitutional powers of the state legislature to impose taxes on mineral rights in contrast to the constitutional powers of the parliament. On one hand, the parliament has the power to legislate on the subject matter, regulation of mines and mineral development, and the parliament exercising this power has enacted the MMDR Act, which provides for charging of royalty on the holder of mining lease in respect of any mineral removed or consumed from the lease area. On the other hand, states also have the power to legislate on the subject matter, taxes on land and building, as well as taxes on mineral rights, subject to any limitation imposed by the parliament. So this is the entire finding of the case, that the state governments, they also do have a right to impose tax on the mineral rights, and there is a clear separate distinction between royalty and tax. Royalty should not be mistaken for tax, or royalty should not be confused with tax. Next, we see the EVM VVPAT judgment. What exactly is an EVM VVPAT? What do you understand by EVM VVPAT? Tell me. You can unmute yourself.
Don't know what the
Ma'am, EVM means where we cast our vote, and VVPAT now means VVPAT. We can see ki, whether we can put our vote. It is given to the correct section or not.
Right. So VVPAT is just a slip, the voter slip. If you have already voted, you must have seen that once we vote, we get a slip where the party whom we voted for, its name is there, but it does not come out of it. Later, when the vote is counted, they take the slips away, and that's how they count the votes. So what exactly was questioned in this EVM VVPAT judgment is that the transparency is being tampered in EVM VVPAT. So recently, the Supreme Court in the matter of this case has held that the mere suspicion that there may be a mismatch in votes cast through EVMs, thereby giving rise to a demand for 100% VVPAT slips verification, is not sufficient. Because the people who filed the petition for this verification of EVM VVPAT, they wanted to bring back the ballot paper system. Ballot paper system used to be there before. That did not have any machine or anything as such. There was not any slip. They used to go, they used to sign the ballot paper, they used to vote in that ballot paper only. But EVM machines, ever since the EVM machine has come into being, we have seen that how many instances are being held of booth capturing. There is always a mismatch of the votes. Some people are getting votes which illegally as well. People are not even voting, but their votes are being placed. So because of that only, this case was filed, that it needs a verification. It is actually tampering with the transparency of the free and fair election. So like the way we saw electoral bonds case, similarly it is also an election case. This case relates to the petition challenging the EVM machine. So the petitioners do not allege any motive, malice on part of the ECI or claim that the EVMs have been rigged to favor any candidate or party. However, they argued that due to possibility of manipulating EVMs, there is a suspicion and lack of confidence among the voters. So the petitioners alternatively argued for the returning to the proper ballot system, allowing voters to verify and deposit the printed voter verifiable paper audit VVPAT, 100% counting of VVPAT slips, and voters have the fundamental right to know. Again, we come down to that right to know or right to information, which we saw in the electoral bond scheme. The findings of the court observed that there is a stringent system of checks and balances in place with EVMs and VVPAT, and there has not been any kind of manipulation with the EVMs. And it is not even possible to go through all the slips, and 100% verification is not possible ever. It's not humanly possible. Because of which the court felt that if we try to challenge everything, then in that case, yes, someone has raised hand. Rajan. You are not audible. Hello.
It was by mistake, sorry.
Okay, sure. So the court observed that there is a stringent system of checks and balances in place with EVMs and VVPATs to prevent any possibility of miscount of votes and allow voters to know that their vote has been counted as recorded. This system is more satisfactory compared to the earlier paper ballot system because EVM actually makes the work easier. Paper ballot system, it was actually a very complicated work to be very honest. And now the EVM machine has come into being. The entire system has actually become very smooth. Although there are manipulation, there are instances of manipulation, but we cannot completely guarantee that there would not be any manipulation of the ballot papers as well. If the manipulations or if the rigging are supposed to take place, they will take place anyway, irrespective of the system that we are following. So the court stated that writ petitions should not be entertained if they are based on mere suspicion. There has to be a reasonable ground, reasonable nexus has to be there. Otherwise, if you are just filing petitions just on the basis of mere suspicion, that leads to a lot of cases, and it's not possible for the court to adjudicate upon each of the cases either. So the doctrine of res judicata applies to writ petitions as well. Res judicata means things already which have been decided. If you are bringing it up again, that actually takes the court's time. Now, next we see on the specific issue of doubting the efficacy of EVMs, the court observed that this has been raised before and needs to be definitively concluded now. It already had been filed before, so it needs a conclusion. It needs to end now. Regressive measures like reverting to paper ballots cannot be adopted unless substantial evidence is presented. The court emphasizes that need to maintain a balanced perspective, avoid blindly distrusting any part of the system, and adopt a critical yet constructive approach guided by the evidence. So, court actually wanted to rely on the evidence since there was not any evidence, proper evidence presented to the court. So, the court kept the matter aside. Next, we come down to a very popular case, which is actually a very important one for the law students as well as very applaudable initiative, I would say, on the part of the Supreme Court as well as on the BCI, since it is an enrollment fees case. So we all know that how after you pass BLLB or LLB, when you go and get enrolled, there used to be a huge amount of money which used to be charged on the students. 40,000, 50,000, in some places even 80, 90,000. That's what I have heard. Now, this is not actually as per the law because Section 24(1)(f) of the Advocates Act clearly mandates that the charge should be 750 for the general candidates and 125 for the SC/ST candidates. So when you are charging exorbitant amount of money like 50,000, 60,000, it's not humanly possible for every student to pay that amount of money to get enrolled. So because of which this entire matter was supposed to be taken up by the higher judge bench. Now, this Advocates Act was enacted to consolidate the amend all the laws. So it explicitly mandates what amount of money should be taken from the law students to get themselves enrolled. Now, this additional charges led to the significant variation in the total amount because there are so many state bar councils. Like what I have heard is that there are some bar councils in like UP or Delhi, even I think Jaipur, Rajasthan, in all these places, they charge very huge amount of money. Even West Bengal also, I have seen that they used to charge a very huge amount of money, at least 40,000, 50,000. So the petitioner, someone has raised a hand.
It was highest in Odisha. It used to be around 45,000.
Right. So the charges have always been so high that it's not at all reasonable. And it is not even in the act. So what you are doing is completely violative of the act itself. So the petitioner contended that this additional fees were in contravention of the statutory provisions and imposed an unjust financial burden on law graduates, particularly those from economically weaker section. And I think for most of the students, because the fresh law graduates, they do not have that amount of money to get themselves enrolled because they haven't even started practicing. So what you are charging, it's completely arbitrary. Now it has been struck down. So the BCI now charges the 750 and 125 only. The court analyzed the statutory framework and actually laid down a guideline to all the state bar councils as well as the BCI to take the amount of money which has been stipulated in the act itself and not 1 penny more than that. Next, we would see the court also addressed the constitutional implication of the fees charged as well, because it is violative of, as I already have stated, Article 19 as well as the Article 14. The last case law, last case law. Sukanya, Shantha versus Union of India. This caste-based discrimination in the Indian prisons. Now, you might wonder that in prisons, what might be the discrimination? What might be the caste-based distinction? Because all of them should be put on the equal footing, right? The main identity or the main recognition of them is they are prisoners. They have been convicted of some crimes, that's why they are prisoners. But surprisingly, the prison manuals of the states, they have very wonderful statements that you would be able to see. I have actually noted down that Rule 1017 of the West Bengal Jail Code says any prisoner in a jail who is of so high a caste that he cannot eat food cooked by the existing cooks shall be appointed a cook and be made to cook for the full competence of men. So you can see that how the Brahmin and Dalit, this segregation, this distinction has been there in the jail manuals for times immemorial, I think. Now, Rule 289 of the UP Jail Manual also provides that a convict sentenced to simple imprisonment shall not be called upon to perform duties of a degrading or menial character unless he belongs to a class or community accustomed to perform such duties. This is the regressive methods that have been adopted by these state governments and have been laid down in their own jail manuals for ages. They are explicitly mentioning that menial nature or menial character. They are assessing the character of the prisoners on the basis of the caste. So this discrimination has been there for ages and it has not been addressed properly either. So this Sukanya Shantha case was for the very first time, it addressed the entire issue of this caste-based discrimination. Now, it was held that whether the provision relating to the habitual offenders target the denotified tribes and violate their rights or not, and whether the entire prison manual needs an overlook or needs a check or not. So this was the question of law put before the court. The court recognized the caste-based discrimination inside prisons reflects broader dynamic and systematic inequalities which are contrary to the values enshrined in the Constitution. We already have seen in the Davinder Singh as well as the Young Liars Association case, Indra Shahani case, all of these cases are all about the caste distinction or the caste discrimination. Now, when maybe in outside we can still address this issue, but when these things are going behind the bars, we are not even aware what exactly is happening. So oftentimes what happens that these things do not come to our notice. So fortunately, through the articles, through the research papers of some people who actually try to conduct service on these things, they bring these things to our attention, and that's how these things are brought to the court of law. So unconstitutionality of the discriminatory provisions were actually addressed in this case law, and this prison manual was amended through this Sukanya Shantha case law, as these were being violative of the Article 14, 15, 17, 21 as well as the 23. Now, the amendments to the Model Prison Manual, the Union government was directed to update the Model Prison Manual and the Model Prisons Correctional Services Act to address the caste-based discrimination comprehensively. Clarification on habitual offenders, Reference to habitual offenders in prison manual must conform to the definition under the relevant state legislation. So in every possible way, they tried to discard and they tried to remove all the distinctions that are there, all the regressive statements that have been made in the model prison manuals through these amendments. Last case law that we come down, which is a very popular case law, that is the Bulldozer Action judgment. Before we move on to the case law, if you have gone through the judgment, you must have seen that how B.R. Gawai, Justice B.R. Gawai started the entire judgment with a very beautiful quote, a Hindi quote or Hindi poem written by a Hindi poet, that is the अपना घर हो अपना आंगन हो इस ख्वाब में हर कोई जीता है इंसान के दिल का यही चाहत है कि एक घर का सपना कभी ना छूटे. So this is a very famous poem by the Hindi poet Pradeep, and it states that how house is the embodiment of the stability of the emotions of a person. So maybe the person who we are talking about, he belongs to a rich class or maybe he belongs to a poor class. Irrespective of that, house is the most important part to everyone, because even to the poorest man, they hold on to the hope of having a roof over his head. So when it is taken away for a reason unknown, that leads to the arbitrary and misuse of power of the executive. So this is the case law all about. In a batch of petition challenging the Bulldozer Action, you must have seen that how in the past few years we were coming across incidents where certain communities were being targeted for committing minor offenses, or maybe offenses which haven't even been proved before the court of law. They haven't even been convicted. But whatever the offense may be, if you are using bulldozer like an enforcement measure or punitive measure just to destruct the houses of the people, that is completely an arbitrary, an autocratic misuse of power, I would say, because these things cannot happen in democratic society. Now, because of which this entire batch of petitions were taken up by the Supreme Court. So Supreme Court, it's not exactly a judgment, that the Supreme Court laid down a guideline, because it is not a happy sight, as B.R. Gawai also stated. I would like to record that thing. It is not a happy sight to see women and children and aged persons dragged to the streets overnight. Heaven should not fall on the authorities if they hold their hands for some period. So we all know about this principle of separation of power, right? So what do you mean by separation of power? What do you understand by the separation of power? I'd like to know about it from you all. Yes?
That the legislature, executive, and judiciary are both different parts, and they each have their own powers and roles.
Right. So they should not encroach or they should not intervene into the working of the another. Their power should be kept separate from each other. There should not be any kind of intervention into the working or decisions of the another person. So adjudicating upon the matters, convicting a person, whose work is this? It is the work of the judiciary. But if the law is being taken up by executive, that is a misuse of power, as well as that is an infringement of the principle of separation of power, as had been stated by Montesquieu. So the court said that the principle, an accused is not guilty unless proven. So innocent until proven guilty, we all know. So in a court of law, it's the foundational principle of any legal system. The court maintained that the trial must be fair and open, but not prejudiced by public clamor. Hence, considering the grievances of the petitioners in light of these principles, the court viewed that if a citizen's house is demolished merely because he is an accused, or even for that matter a convict, that too without following the due process of law, what we know is that whatever happens, you have to follow the due process of law. Article 21, everyone is entitled to Article 21, and right to shelter also is within the purview of Article 21. So nobody shall be punished unless and until it is following the due process of law or it is accordance with the law. So the court ruled that executive cannot declare a person guilty, as this process is the fundamental aspect of the judicial review. It is subject to the judicial review. So when you are taking the law up in your hand, what happens is that we get to see that it is completely an arbitrary exercise of power. You are destructing houses for reason unknown. This is not a happy sight. Now, the court felt the need to take up the matter in the hand, and they actually laid down a range of guidelines that we will get to see. That court gave the following directions: that no demolition is permissible without a so-cause notice. If you are not giving a notice to the person, if you are not letting the person prepare, maybe let's say you are taking the measure to destruct someone's house, or you are calling the house an illegal property or unauthorized structure. What we have seen is that the unauthorized structures are there and those are not being demolished. Rather, certain communities are being targeted. So this is actually proving that there is a malafide intention behind it. So adequate time has to be granted. If you are considering something an unauthorized structure, grant them an adequate authorized or adequate time. Otherwise, you cannot just expect that the person would vacate the house overnight. You are destructing the house saying that it is an unauthorized structure that does not have a reasonable ground. So the demolition notice shall be served upon the owner, occupier by registered post AD and affixed on the outer portion of the structure. So to prevent any allegation of backdating as the so-called notice is duly served, intimation also has to be made to the DM of the respective district. The notice shall contain the following: the nature of the unauthorized construction, the details of the specific violation and the grounds for demolition, list of documents that the notice is required to furnish along with its reply. And every municipal local authority shall assign a designated digital portal where the grievances can be also made. And whether the notice has been properly served or not, that also has to be taken into consideration by the court before they move on to the destruction of the houses. So these were the guidelines, and the final order passed by the designated authority shall contain the contentious of the notice. And if the designated authority disagrees with the same, the reasons thereof as to whether the unauthorized construction is compoundable or not, if it is not so, the reasons have to be stated, why you are considering it to be an unauthorized structure. These are the ways through which the Supreme Court felt that they can actually curb down or they can curtail this misuse of power of the executive. If the statutes provides for an appellate authority as well, there has to be an adequate time provided for the filing for the same. 15 days time period has to be provided to them before demolition, and inspection also has to be done by the authority concerned. So the said demolition report should be forwarded to the municipal commissioner by email and shall also be displayed on the digital portal. Considering that the right to shelter has been brought within the purview of Article 21, the court observed that punishing persons who have no connection with crime by demolishing the house where they live or properties owned by them is nothing but an anarchy and amount to a violation of the right to life Constitution. So these were the 10 case laws and the analysis of the 10 case laws that we have seen or we have considered as the most important ones in 2024. However, there are so many more case laws on JJ Act, on PMLA, on POXO Act, which cannot be discussed in one session.